Delhi High Court on Monday quashed a false information report, that is an FIR registered against a second-year law student who had appeared before a district court as a proxy counsel for a lawyer and had sought an adjournment in a case. Observing that FIRs must not be registered against law students for posing as lawyers before courts, the Delhi High Court has said that they should be counselled instead. Quoting from the order, it is understandable that presiding officers take an objection where law interns tend to pose as lawyers, but on the other hand, these law interns who are merely students should be counselled, properly informed and instructed rather than FIRs being registered merely on this basis. Justice Anish Dayal said that a law intern is a student who is in process of understanding the court practice and procedures, and therefore it is the duty of the institution to take adequate steps to facilitate their education and training and not simply punish them for those inadvertent acts. However, the High Court went on to state, and I quote here, that is not to say that it is an appropriate case where a person who is not enrolled as a lawyer is wearing lawyer robes and categorically representing himself as a lawyer, there would not be a case for some opprobrium and necessary action. To provide a bit of context for all of you, the High Court made these observations while quashing an FIR against a third-year law student who had sought an adjournment before a metropolitan magistrate in Dwarka courts last year as a proxy counsel after being instructed to do so by the advocate. However, he was neither wearing any band nor lawyer robes. The counsel representing the law student submitted that he was under the mistaken impression that a proxy is somebody who seeks an adjournment and that he was not sure about the ramifications of the same. On the directions of the Metropolitan Magistrate, a copy of the court proceedings and student ID proof of the law student were placed before the concerned principal and district sessions judge, who declined to take any legal action since the petitioner was a law student. However, the FIR was registered on the complaint of the Secretary of Dwarka Court Bar Association. The FIR was registered under various sections of the IPC. Quashing the FIR, Justice Dayal said that the issue was amplified disproportionately before the Metropolitan Magistrate, particularly when the law student, upon being queried, fairly disclosed that he was an intern and also gave his ID card proof upon being asked to do so. It was not a situation where an intern was wearing the robes of an advocate or had stated that he was an advocate. In his understandable nervousness, if the intern stated he was a proxy, it would be a bona fide mistake since the word proxy is used informally in courts for an advocate who is not on record appearing before the court, but also is not a formalized term of art which would be taken into account to implicate the law intern for an alleged offense of impersonation, furnishing false information, or dishonesty making a false claim, the court further stated. The judge also said that there was scope for clearer messaging on the part of practicing advocates who ought to instruct their law interns on how to represent themselves in courtrooms. He also noted that interns themselves must be careful. The bench further noted that the petitioner has submitted an undertaking that he understands that he is not an enrolled advocate and that he will not appear or project himself to be a lawyer in any court proceeding henceforth. For more information on this ruling, you can refer to a detailed report, the link to which has been given in the description box below. Thank you. I'm Aratrika Bhavik for LiveLaw. Keep watching LiveLaw for more such updates.